Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5122. Virgin Islands Housing Finance Authority Appellant versus Federal Emergency Management Agency. Mr. Bargava for the appellant, Ms. Smith for the appellant.
Good morning.
Good morning, Your Honors. May it please the court, my name is Michael Bargava, and I represent Appellant, Virgin Islands Housing Finance Authority. This court should overturn the lower court's decision for two reasons. First, appellant should have been permitted to proceed under the Administrative Procedures Act with a challenge to a final agency action by the Civilian Board of Contract Appeals. The evidence shows that Congress didn't intend to displace broad APA review with a much more cramped review process under the Federal Arbitration Act. And second, even if the FAA applies, the statute of limitations was never triggered because the board's decision was void ab initio. Void decisions cannot trigger statutes of limitations. On the first point, the APA should clearly apply here. The board is a federal agency, and its decisions constitute final agency action that are subject to APA review. The APA is Congress's way of reining in improper agency action that's arbitrary and capricious or that exceeds the agency's powers.
So in the realm, though, of arbitration, there seemed to be a default way of appealing arbitration awards. And it seems that Congress would be aware of that. And yet they didn't state explicitly or otherwise that they contemplated anything different. It's just, it would undermine the efficiency and efficacy of arbitration if there were some other way to appeal an arbitration.
Well, Your Honor, it may be the default way of appealing for private arbitrations. This is government action here. And so the question is whether the APA applies. The Congress understood that in order to make the FAA apply, it had to specifically say that in the statute. And that's exactly what it did in the Contract Disputes Act. The board conducts arbitrations both under the Contract Disputes Act and under the Stafford Act. In the CDA, it said specifically that the FAA would apply for review. In the Stafford Act, which is what we're dealing with here, it chose not to do so.
I understand that. It just seems to me that there's sort of an overarching purpose for arbitration, which is to do this efficiently and more quickly and in a more simple way. And to promote that, there are just very limited ways in which you can appeal an arbitration award generally. And even the APA itself says, like when we're talking about arbitration awards, we don't give them the full APA arbitrary and capricious review. So it just seems that it's an uphill climb for you to say that arbitration awards should be reviewed using APA standards.
Well, Your Honor, as you know, the standard here is congressional intent, and whether Congress intended to apply APA review or intended to displace APA review with some other review procedure. There has to be.
What's your strongest argument that that's what Congress intended here?
Well, first of all, it didn't write it into the Stafford Act, which
it didn't write it one way or the other.
Well, it chose to do so in other actions, including the CDA, but it chose not to do so for the Stafford Act. So that's one indication that there's not clear and convincing evidence. The second issue is that the review process is not at all similar between the APA and the FAA. This court, the Supreme Court, have always held that essentially you have to have a process that mimics the APA, have a de novo review process. The FAA doesn't come close to it. It has a very meager standard. It only allows courts to overturn decisions for fraud, misconduct, similar egregious behavior. It doesn't allow courts to look at the merits of any decision. And so there is essentially no review process for an arbitral award by the board here under the Stafford Act if we're saying that the FAA applies.
But what you're asking for, though, is vacating the award, which you can get under the FAA versus.
Well, 2 points on that, Your Honor. First of all, the test is not whether what the individual plaintiff asks for, it's whether Congress intended to displace the APA for the FAA.
Well, under CREW, isn't it whether it's what you asked for and then also is it adequate? Our CREW case seems to acknowledge both of those.
It does seem to acknowledge both of those, Your Honor, but the standard that has been applied is whether there's congressional intent, whether there is clear and convincing evidence of legislative intent to displace the APA. And second on that point, Your Honor, is that the relief would be different under the FAA and the APA. Under the FAA, all that the court can do is displace a single arbitral award that applies just between the two parties here. Under the APA, it's required under Section 706 of the APA to hold unlawful and set aside any agency action that's improper in whatever way. And so that is prospective relief as well. It's telling the board that it has to vacate the entire practice of issuing decisions in this kind of way in violation of its own rules. Yes, sir.
Sorry to interrupt. In terms of precedent, have you found any case where a court has reviewed an arbitration award under the APA?
I have not, Your Honor, but this is a case of first impression, both before this court and in fact, in any court of appeal. I have not found this issue, whether the FAA displaces the APA. I don't think any court has dealt with this issue.
So how do you reconcile what you just argued with CREW? Because in CREW, there was an argument that there was an inadequate remedy under the FOIA because FOIA would not grant the relief of putting the documents on a public website. It would only grant the relief of giving the document to the plaintiff. And we still held that it was adequate, that FOIA was an adequate remedy.
So in CREW, Your Honor, the difference in terms of the relief was quite marginal in terms of whether they had to produce the documents, as you said, to the individual plaintiff or publish it in the Federal Register. The court didn't hold that under the APA that it could require the government to publish the OLC decisions in the Federal Register. But here, the difference between the FAA and the APA is quite stark in terms of the remedies available. There are preliminary injunctions here. There are various writs that are available under the APA.
But you're not requesting any of that. And how would that be a remedy for an arbitration award on wrong?
But again, the standard, Your Honor, is there has to be clear and convincing evidence of congressional intent to displace the APA. And there's just no such evidence here, both because it didn't say so in the statute and because both the scope of review in terms of the de novo review process that's available in the APA is far greater than what's available under the FAA, and in terms of the overall remedies that are available under the statutes are very different. I'd like to reserve the rest of my time, if I may. Thank you.
Thank you.
May it please the court, Sarah Smith on behalf of the government. In 2018, Congress amended the Stafford Act to give applicants seeking to challenge FEMA's funding determination two choices. After first appealing the decision to the FEMA regional administrator, the applicant could either pursue a second appeal within FEMA and, if unsuccessful, seek judicial review in a district court of FEMA's determination under the APA, or the applicant could submit the dispute to arbitration before the Civilian Board of Contract Appeals. Petitioner here chose to arbitrate, and they did so with the understanding that the board's decision would be binding and, like arbitration decisions generally, subject to limited judicial review. In the Federal Arbitration Act, Congress provided a review procedure for parties seeking to challenge arbitration decisions. 9 U.S.C. 10 authorizes district courts to vacate arbitration decisions in certain circumstances, including in the circumstance that petitioner alleges here, which is that the arbitrator exceeded their powers. Because the FAA provides an adequate remedy, APA review is not appropriate here.
Can you talk about this argument that the authority says FEMA cannot simply undo a statutory requirement under the APA by promulgating a regulation permitting review only under the FAA? So I understand that the act contemplates arbitration, but as I understand their argument, it's the regulation that says review will only be under the FAA. So their argument is a regulation can't preempt the statute.
So had Congress provided in the Stafford Act that review of these decisions was under the APA, then it is absolutely true that FEMA could not promulgate a regulation saying review is limited to the FAA. But here, Congress did not limit review in the Stafford Act under the APA. The FAA provides the general background principles of how courts review arbitration decisions. And under the APA, the question is just whether there is an adequate remedy in a court. As we've explained, the FAA provides that adequate remedy. It provides vacatur of the decision, provides it on the exact grounds the petitioner is seeking here. The only problem for petitioners is that they didn't comply with FAA's notice requirement. That's why they need APA review. But that is not a grounds to get review under the APA.
So the Stafford Act is silent. That means the default rule kicks in, and the default rule comes from.
It comes from the FAA, which is clear that it's Congress set out, here are the conditions under which a district court can vacate an arbitration decision. In Hall Street Associates, the Supreme Court was clear that that list is exclusive. Parties can't even, by contract, agree to more expanded judicial review. So when Congress amended the Stafford Act to say, applicant, if you like, you can arbitrate, it did so, it put the petitioner on notice that that decision would be under the limited judicial review that's available under the FAA.
I think this is a friendly question, but do you think the Contract Disputes Act reinforces that or applies its own default? Reinforces that default rule. It says an award by an arbitrator under this chapter shall be reviewed pursuant to sections 9 to 13 of Title IX, which is the FAA, except, and then it has an exception.
Yeah, absolutely. So it made sense. In the Contract Disputes Act, Congress wanted to provide for an expanded review, not just the FAA, but they also wanted to provide this additional basis on which a court could vacate an award. So it makes sense that Congress included that review provision because they were providing something more than the default.
That's not it's not doing any work in this case.
No, they're just separate authorities. That's right. I'm happy to say a few things about petitioner's claim under the FAA. The district court correctly determined that review is not available under the FAA because petitioner failed to comply with the Act's notice requirement. On appeal, petitioner does not argue that they complied with that statutory requirement. Instead, they argue that the statute of limitations does not apply here. But that argument just confuses the grounds on which a decision could be set aside with whether there's a decision at all. And here, there's clearly a decision. It's in effect until a court sets it aside.
But if they're right, though, there wouldn't be a decision because it would be void ab initio. If they're correct that a decision made without a quorum is void ab initio, then the statute of limitations wouldn't kick in. And
No.
we do have precedent in Noel Canning that a decision made without an adequate quorum would be void ab initio. That doesn't mean that there wasn't a quorum in this case, but I'm saying if they were correct that there was no quorum, then it would be void ab initio, right?
So the problem with petitioner's argument is that they're trying to argue that it is void, and so therefore they do not have to comply with the statute of limitations at all.
Correct.
Practically, there are huge problems with that. It would mean that a party could come in a decade later and say that this arbitration decision should be set aside. And when we think about the virtues of arbitration and providing an efficient and final resolution, that's a very troubling result. But again, the key problem with their argument is that they're saying that this grounds for which a court could vacate means that there's no decision at all until a court says that
Is there something different between this particular type of grounds, which is that there's no quorum, so the tribunal had no authority to act at all. That's basically what they're saying. And that you could raise. It's kind of like a jurisdictional argument, which you can raise at any time. There's no statute of limitations problem with that.
Well, so again, if we think about, comparing this to, say, a party who loses in district court and wants to challenge the district court's order because it didn't have jurisdiction, we wouldn't say that there wasn't an order there, and a party seeking to challenge the district court's order would still have to comply with the notice of appeal deadline.
No, of course, I'm saying, I think, my question is there a specific type of claim, such as the one that's being made here? There are claims in which an order is void ab initio, and if an order is void ab initio, you would agree that the statute of limitations doesn't kick in.
No, because, okay, so under, as the,
Ever a void ab initio order, so that there's no order, the statute of limitations still applies?
in this context,
I'm just
Where-
asking you generally.
that might be in a different case. I'm not sure, but here,
All I'm saying is their premise is this order is void ab initio. And I'm asking you, if an order is void ab initio, the statute of limitations does not apply, correct?
so here, the FAA clearly, Congress envisioned that a party might want to bring this sort of argument that an award was invalid. That's a possible
I'm saying,
basis.
aside from award being invalid, I'm saying a particular type of invalid award, which is not a.
After
don't
it
even
has
worry about
been,
the quorum, just if it's a award that's void ab initio, the tribunal had no authority to issue the order at all. There is no statute of limitations issue in that context, correct?
but I think a court has to declare that it's void ab initio. The party just cannot
Correct.
declare it void ab initio.
Correct, which is why I think we have to look at the merits of their argument to determine whether the statute of limitations even applies. Because the argument is, and it could be incorrect, is that the order is void ab initio. And if that's the case, we have to determine if there's an order or not before we determine whether the statute of limitations applies, correct?
I'm happy to talk about the merits if Your Honor is interested in them.
But is that
But-
analytically correct?
I don't think so here because the FAA clearly provides that the notice requirement, the 3-month notice requirement, applies to petitions filed seeking vacatur under 10A4, which is, as petitioner argued here, that the arbitrator acted without authority. So the statute provides that you still have to comply with the notice requirement, even when your argument is that there was no valid decision rendered. So
And your
I'm not
argument
sure how they can
assumes
get around that.
This type of argument is just like any other invalid award argument.
Yes, yes. And the other problem with their argument is that if they're not arguing for vacatur under 10A4, then I'm not sure under what grounds they think a court could vacate the award because, as I said earlier, the Supreme Court has made clear that the list, the basis for
Well, they're saying
vacatur.
void ab initio, vacated void ab initio. The tribunal had no authority to issue.
That again, it just gets them under 10A4, and then they need to comply with the notice requirement.
I understand your position.
Isn't part of your argument also that there are all kinds of arguments under 10A4 that sound like they would render a award void? So one of the most
Absolutely.
common 10A4 grounds that I'm aware of is we never agreed to have the arbitrator decide this issue.
Mhm.
And so it's void.
Absolutely,
That's just
absolutely.
another way of saying they exceeded their powers. It's a run-of-the-mill challenge under the FAA. that
Yes,
Courts always apply the 3-month time limit to, right?
absolutely. If there are no further questions, we ask the court to affirm the district court's judgment.
Thank you.
So just a couple quick points. The government is arguing that the FEA should be the default here. But that's, again, not the standard. The APA is the default, and the Supreme Court and this court have said over and over again that the APA applies unless Congress specifically intends to displace it. Again, there's no such evidence here. On the void ab initio issue, the government's argument is contrary to the Supreme Court's holdings, this court's holdings, courts of every court of appeals that has looked at this issue, is that if a decision is
Do any
void-
of those decisions you're talking about involve an arbitration award?
No, they don't specifically.
So
but
there's
they-
many, many cases that addressed this argument. The government didn't cite them in their brief, but arguments that an arbitration award is void or issued without jurisdiction are still subject to the 3-month time limit. And I don't think there's a contrary case out there. And the reason for that is that the whole point of arbitration is to settle disputes quickly. So much like all the reasons the FAA applies here, The concern is that you could sit on an argument. This case doesn't involve that. You missed the time by a day, but we don't want to have people able to bring up an argument at any time. And so you would be opening a pretty big hole in this 3-month time limit, wouldn't you?
No, Your Honor. As I understand those decisions that you're referring to, the decisions are not declared void ab initio. This is exactly like the Supreme Court's decision in New Process Steel, this court's decision in Noel Canning, where there was a lack of quorum for the decision makers here. And so in those cases, the decision is void ab initio, and so there is no statute of limitations.
Do you think that when an arbitrator issues a decision on a subject the parties didn't agree to arbitrate, wouldn't that make it void ab initio also? They had no contractual authority to issue the award.
I don't think those decisions are not declared void ab initio, as I understand it. It's declared under the FAA not to be within the scope of what the parties agreed to. But it is, again, under these decisions, if it's void ab initio, which it is if there's a lack of quorum in this specific case, then there is no statute of limitations. Thank you, Your Honors.
Thank you.
Case number 24-5180. Agendia, Inc. Appellants versus Robert F. Kennedy Jr., Secretary, United States Department of Health and Human Services. Mr. Hooper for the appellant, Mr. Shaw for the appellee.
Mr. Hooper, can you hear us okay?
Yes, I can, Your Honors, and I hope you can hear me.
We can hear you great. Proceed when you're ready.
Okay, thank you very much. May it please the court, Patrick Hooper for the appellant, Agendia, Inc. And I wish to thank the court and opposing counsel for allowing me to appear remotely. Agendia seeks Medicare coverage and payment for tests it performed between 2012 and 2015. The testing was performed for tests at the request of each patient's treating physician. The testing provided each doctor with specific information about each patient's unique breast cancer, and such testing gave the treating doctors more accurate information than would be available and could be obtained by viewing a specimen from each patient's tumor under a microscope. We're here in 2025, 10 years after the most recent claims, because Agendia was required to go through each step of the Medicare multi-step administrative appeal process for each different beneficiary. If Agendia had tried to bypass that process, as this court knows, a reviewing court would not have had jurisdiction. This is one reason we contend that each claim before the court now is separate, and each is a separate cause of action, even though you can combine some to for efficiency purposes if you meet the time limits. But the different claims could not have been tried together. They could not have been tried as part of the Agendia 1 situation, and therefore they're not what we would call a convenient trial unit for purposes of both collateral estoppel or res judicata. And furthermore, the Secretary's substantial deference regulation bolsters this characterization of these claims being separate and distinct. The regulation requires the government adjudicator to apply substantial deference to local coverage determinations for each claim. And then the adjudicators must apply the standard not only to each claim, but the laboratory in this case, as opposed to a beneficiary, was not even permitted to pursue a facial challenge to an LCD because
Can I
under the
ask you-
regular.
Can I ask
Pardon
you a
me?
question about this process?
Yes.
It just seems to me that the LCD is a really important determination because it gets all this deference later down the line. And I'm just wondering if that process gives Agendia and other providers an opportunity to appeal or reconsider or participate in that determination, the LCD determination. Because it seems like once you're challenging it further down the line, it's a lot harder because.
Yeah. They do not have the right, Your Honor. Congress has two avenues available to challenge an LCD. One is only for beneficiaries for some reason, and that is found in the statutes and in the Secretary's regulation. A provider can only challenge the application of an LCD or an LCD itself once it's applied, once the LCD is applied.
What about the MALDEX? Do you participate in that whole MALDEX review on which the LCD is based?
During the period where at issue here, there was no process for a provider to participate in. There was no what I would call a quasi-legislative process for enacting LCDs during the period at issue here, as the government can confirm. In
But
2006,
the MALDEX, you have to provide all the data that they look at, but then there's no iterative process where you get to confer during that process?
A provider does have to provide documentation. I believe there may be some kind of informal back and forth. And, as the record shows here, for Agendia's mammo print, it was approved by MALDEX. But for the two tests we're talking about here, MALDEX did not approve. And I will represent to the court, Agendia has tried to get some kind of approval, has not been able to be successful, which means the only way it can get paid and covered for its testing ordered by the physicians, is to go through this process. And then this process is basically a process where the LCDs almost always win. I wanted to almost in every one of these cases here, there were 6 cases if you count Agendia's first case in front of the Ninth Circuit. 2 administrative law judges have said that they are not going to apply the LCD, or actually with Judge Amendola in this case, he said, I am applying it, and I think the criteria even fit the LCD. But most of the time, these are close cases, they're complicated cases, and unlike any administrative appeal process I've ever seen, especially in Medicare, there is this presumption that an LCD, a policy, a very important policy made by a private contractor, seems to trump every other argument. I've never seen an administrative appeal process, perhaps the court has, where the government adjudicators must give substantial deference to the policy made by a private contractor. A policy that the Ninth Circuit says doesn't even have to be enacted as a regulation, because it's just the private contractor's view of how the statute should be interpreted. But by the time it gets through the administrative appeal process,
even if you're
it's
correct,
entitled to
though,
all kinds of weight.
Even if you're correct, though, isn't your claim precluded because you could have raised?
Well, I think there is well, let me go back. I do not believe, most respectfully, that these are considered to be the same claim, same nucleus of facts. And that's because we could never have combined them because of the time limits for appealing them, the requirement to appeal each claim separately.
Since
Mr. Hooper,
Yes.
you go for it. I bet we're gonna ask the same question.
maybe. So set aside that point. I appreciate that argument. Every new claim giving rise or tranche of claims giving rise to a new cause of action. Just as a practical matter, if you set that argument aside, would you agree that you could have argued in the Ninth Circuit, for example, that the regulation is contrary to the statute, that all the relevant facts were present at that time?
I agree. We could have done so, Your Honor. You're correct. The critical point, and I realize that creates a problem for claims preclusion, but for issue preclusion, which is not really now a question, we have to keep in mind the Ninth Circuit did not expressly rule on that issue. But yes, we could have done so. I will be as candid as I can, having handled that case. We thought we could prevail on the other issues, and we were under Chevron at the time. The court hadn't given us the Loper decision where.
I appreciate that argument also, but just the basic claim preclusion, I think the difficulty for you is getting around NRDC, the NRDC decision. So if you have a distinction of that, I would love to give you the chance to make that argument.
Yes, I get that. I think we look at the, and I hope I'm pronouncing this correctly, the Appellant decision, which allowed, and this may be dicta, but it's pretty clear dicta, that where in a small set of cases, a change in the controlling legal principles may allow a party to relitigate a claim that would otherwise be barred by res judicata. Government says, oh, that only applies to constitutional issues. It's not limited to constitutional issues. And if Loper doesn't qualify as one of those kinds of changes in the controlling legal principles, I can't think of another case that would. And it's directly on point here because you're dealing with this whole concept of deference. And there's nothing anywhere in the statute.
Has there been a case in this circuit where we actually did decline to apply claim preclusion because of an intervening precedent?
I have not found one. I find the dicta, Your Honor, I've not found one. I'm hoping that this might be that case. But I do think we have two ways of getting at it, the separate claim concept and then the Loper concept. But let me move on quickly. Oh my, I'm almost out of time. May I just complete my thought and then?
Sure, that's no problem.
Yeah, just on Judge Amendolla's decision, which is unique, even res judicata applies, Judge Amendolla's decision is not bound by that. And in Judge Amendolla's decision, ALJ Amendola, he found in favor of the provider, and the appeals council could only overturn that on a legal issue. It did not overturn it on it overturned it on a legal issue, saying you should apply this bar, you should have applied substantial deference. But the district court then said, well, we'll look at substantial evidence, and then it went into a discussion of whether there was substantial evidence. That issue should not have been before either the Medicare Appeals Council or the district court, because the Medicare Appeals Council only had the issue of whether there was some legal problem, and it never ruled on the sufficiency of the evidence. Judge
Is that
Amendola,
argument preserved, the one that you're making right now?
yes.
Where did you argue that previously?
When you say preserved, do you mean in the district court, or where do
Yes.
you mean?
In the district court?
Yes,
But
I
can I just add, I'm also wondering where in your opening brief. So I think you needed to do it in the district court, as Judge Pan says, and then you also needed to make that argument in your opening brief here.
yes, I believe I did. I'll make that representation. and I believe it was in a footnote, but I can find it. Unfortunately, I know my time is up.
Maybe we'll
So
give you a couple minutes on rebuttal, and if you could try to identify the page number in the opening brief and as well as where we can find it in the district court record. I think
Okay.
that would help us as we try to figure out whether that argument was preserved or not.
Okay, thank
Do you
you.
have any more questions, Judge? Thank you very much. We'll hear from
Thank
Mr.
you.
Goodall.
May it please the court, Whaley Shaw for the Secretary of Health and Human Services. I just want to be clear about what's at issue in this case. I think what's before this court, what's left before this court now are a facial challenge to the substantial deference regulation, and then as applied substantial evidence challenges to two of the individual agency decisions below. So I'd like to begin with the facial challenge to the regulation. What we know from NRDC is that where a party makes repeated challenges to the facial validity of the same regulatory scheme, those claims rest on the same nucleus of operative facts, and therefore the second and further attempts to litigate that facial validity are barred by claim preclusion. And I think NRDC applies perfectly to the facts of this case. I also want to turn to a few of the specific questions that were raised in my opposing counsel's.
Could you just
argument.
address the
Yep.
the argument based on Loper-Bright?
Yes.
We've said sort of vaguely, dramatic shift in the law is not enough. Something else would be enough. What's your argument about why Loper-Bright doesn't fall?
Yes, absolutely. So the general rule, and I'll get to the exceptions, but the general rule is that the operation of claim preclusion is not affected by changes in decisional law. So for example, the Supreme Court said in Federated Department Stores, the effect of claim preclusion is not altered by the fact that the judgment may have been wrong or rested on a legal principle subsequently overruled in another case. This court has said the same thing in the Hardison decision. Now, this court in Hardison also recognized the possibility of a very limited exception to that rule for cases involving paramount questions of constitutional law or exclusive jurisdiction. And as examples of the paramount questions of constitutional law, what this court identified were the constitutionality of multi-member districts used in apportioning school boards and the constitutionality of state tuition grants to private schools. Now, this case does not involve a paramount question of constitutional law. It is a absolutely mind-run APA claim that an agency rule is arbitrary, capricious, or contrary to law. So it simply does not, there's no basis for invoking that exception. So Loper-Bright itself, while it may have altered the way courts defer to agency interpretations of statutes, it does not alter the effect of claim preclusion
Could
in
I
this
just direct
case.
you to one other issue? Thank you for
Yeah.
that answer. So on the Amendola issue, the district court seemed to have held that Agendia forfeited an argument by failing to raise it in front of the council. Do you understand that holding to be that Agendia didn't adequately cite to the studies in its response to the referral notice? Could you just walk us through what you think the forfeiture argument is?
Yes, absolutely. So I think the forfeiture argument is this. What happened is that a Medicare contractor filed a referral to the Medicare Appeals Council, asking the Appeals Council to review ALJ Amendola's decision. And in this referral, the contractor explained that the ALJ had erred as a matter of law by not either giving substantial deference to the LCD or explaining why not. And then furthermore, the contractor asked that the Appeals Council decide that the tests at issue were not reimbursable. Then Agendia filed exceptions to that referral. And in those exceptions, Agendia focused almost exclusively on the sort of legal arguments that were at issue both in the Ninth Circuit and now in its facial challenge, which is that LCDs are invalid for various reasons. Agendia did not present a developed argument for why applying the correct legal standard, which is to apply substantial deference, that the Medicare Appeals Council should nonetheless decide not to defer and therefore rule in Agendia's favor. So it didn't make a developed argument there. And so the district court found that Agendia, by failing to develop that argument, had forfeited it. Now, Agendia notes for the first time in its reply brief it makes for the first time this argument that the Medicare Appeals Council was limited in its ability to consider the merits in order to actually decide the question of whether the tests were reimbursable or not. And I think that rests on a misreading of the regulations. So what the regulations say is that in the particular circumstance of this case, and I quote, in deciding whether to accept review, the council will limit its consideration of the ALJ's or attorney adjudicator's action to those exceptions raised by CMS. And here it was a claim of legal error. But it's important to note that initial clause in deciding whether to accept review. So the basis for accepting review must be a legal error. But once the Medicare Appeals Council actually accepts review, 42 CFR 405.1100C states that when the council reviews an ALJ's or attorney adjudicator's decision, it undertakes a de novo review. And furthermore, the regulations specify that the Medicare Appeals Council can adopt, modify, reverse, or remand the case. So it was fully within the Medicare Appeals Council's authority to, after finding the legal error, to then apply the correct legal standard and determine what the outcome of the case should be, whether the test should be reimbursable or not. And by failing to make arguments on that issue, Agendia forfeited that issue before the agency and then also before the district court. If the court has no further questions, we ask that the decision of the district court be affirmed.
Thank you very much.
Thank you.
May I have just a quick moment, Your Honor? What I would suggest is that the July 28, 2022 document that opposed the Medicare Appeals Council even taking the case, which is found in the joint appendix at page 345, is sufficient to cover any legal issue that was raised and could be raised by the private contractor in order to try to have the Appeals Council take the case. At page 346 of the agenda, or of the documents, the appendix, Agendia specifically, it raises the issue that the department lacks the authority to have a regulation based on substantial deference. Now, as to questions of fact about the sufficiency of the record, that did not have to be raised because, again, the request for the request for the Appeals Council to hear the case had to be based purely on legal issue, not on any kind of factual issue. So the fact that the district court seemingly has confirmed and decided not to set aside Judge Amedola's case because of a lack of evidence in the record exceeded the basis used by the Medicare Appeals Council to set aside the decision. The Medicare Appeals Council does not talk about the sufficiency of the evidence in the record. Nowhere in the Medicare Appeals Council do they talk about the sufficiency of the evidence. Yes,
I just want to give you every opportunity to uh, tell us if it would be a mistake to write imagine we write the following sentence in an opinion, and you read it, and you think, no, that's wrong, and it's wrong because we made this argument on page blank of our opening brief. Imagine the sentence in our opinion says, Agendia argues in its reply brief that it couldn't make evidentiary arguments to the appeals council because the appeals council review was limited to legal issues. But arguments made for the first time in a reply brief are forfeited. So if you read that line in our opinion, you think to yourself, oh, no, that's not fair to us. We actually did make that argument in our opening brief. What page of your opening brief would you point to?
I haven't been able to find that, Your Honor. My response would be, first, I would be disappointed, obviously, but my response would be that we did not have to show insufficiency of the evidence, or I'm sorry, sufficiency of the evidence, because it was an on-the-record hearing. The administrative law judge based his decision on the evidence in the record, and the only thing we were required to object to was the legal issue, the substantial deference issue. So I hope that helps. I can't find the identical argument that pops up in the reply brief. I can't find it in the opening brief.
That's fair. I appreciate that, and I appreciate you looking for it and being responsive to our questions today. Do you have any more questions? Thank you very much, Mr. Hooper.
Thank you very much.